Welcome to another episode of Lawyers for Immigrants with your host, Yifei He, president of the law office of Yifei He, where they are dedicated to helping immigrants and new Americans. In every episode, Yifei interviews attorneys across different practice areas and asks them how they are helping immigrants. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and at www.yifeiheelaw.com. Now here's the host of Lawyers for Immigrants, Yifei He.
Hello, welcome to another episode of Lawyers for Immigrants. My name is Yifei He, the president of the law office of Yifei He, where we're dedicated to helping immigrants and new Americans. Every week, I interview different lawyers across the practice spectrum and ask them how their practice relates to helping immigrants. And today, my show guest is Martin Zhang. Martin and I went to law school together at the University of Connecticut, and he currently is a partner at the law firm of Cesari and McKenna, a patent IP firm located in Boston, Massachusetts. Prior to that, he served for several years as corporate counsel at a major company in New Jersey. So Martin, hello and welcome to the show. How are you?
Hi, Yifei. Good to see you.
Yes, good to see you too. So please introduce yourself and the area of practice.
Yes, I'm a patent attorney and I'm partner at Cesari and McKenna, just as Yifei just mentioned. Our office in Boston, in the financial district. So we serve clients all over the places. We have clients in China, in Taiwan, in Europe, and just globally.
Great. So can you tell us a little bit more about what your firm does?
Yeah, our firm, we have 12 attorneys. So all of us are patent or intellectual property attorneys. We just handle some very specialized matters. We've handled trademarks, we handle patents. So that's for businesses, for inventions. That's our focus.
Great. So your firm does intellectual property and your firm does both patents, copyrights, and trademarks. Is that correct?
That's right. Yes.
Okay, great. So can you tell us a little bit about the difference between those three areas in IP law?
Yeah, of course. So maybe let me start with intellectual property. Yeah, so intellectual property is is a kind of intangible property. It's just like a physical, tangible property, but it's created by just a human mind, right? It's just more like your ideas and your expression of your ideas. So this is a very broad category, intellectual property. So under this intellectual property, there are mostly four classes of intellectual properties. There's first is patents, is protecting your inventions, and then there's trademarks. Just this trademark protects the identity of your goods or identity of your service. So your brand names, that's under the trademarks, and copyrights. So this is the expression your idea. Just for example, your music. You made a piece of music that's protected under copyright. Any arts, any books. So this is the copyright. And then there's another one is the last one is the trade secrets. It's just like your valuable information regarding your business. For example, your formula, very secret formula, a very popular one, or your client list can be a trade secrets because that's very has commercial values to your business. So we have four categories: patents, trademarks, copyrights, and trade secrets. So the patent, so it's a patent is a right granted by a government. So it has to be uh, associated with the government, U.S., China, European countries, Brazil. So each individual countries give you, they grant you a right, a exclusivity right. So you can just exclude other people from using your inventions in that country only, right? So you can exclude other people from using it, from making it, from selling it, from just importing or exporting it. It's very powerful, right? If you have invention, if you get a patent, nobody can touch it. Only you can use it. That's make you very strong in the market. So you have very strong position. You can charge a lot, so much a premium price for your products if it's a very unique. For example, a lot of pharmaceutical companies, their price is so high, the drug price is so high. Why? They put a lot of money to develop it, but the other reason is that nobody can sell that product because they have patent protection. So that's why they can asking for more prices. Otherwise, if there's competitors making the same similar products, the price will much lower. You can imagine that. So the patent is very valuable if you have good invention, but patent only give you a limited time of protection. It give you probably just 20 years in most countries, 20 years counting from the day you file your patent application in this country. If you file in the US, you get a 20 years. When you get a patent, you get a 20 years in the US. So you have to go into individual countries, and unfortunately. So if you want the protection in Japan, you have to you file your patent application in Japanese patent office. If you want to protection in Brazil, you have to file your application in your Brazil patent application. So that's you have to be file in individual countries. This is as you can see, this is a lot of it's very expensive process because you when you want to protect in 20 countries, that's every country. If you have just a 10,000 cost, you add up to a significant amount of costs. So this is a patent. And if do you have any question regarding patents? We were going to talk about like trademarks, copyright, trade secrets as well.
Right. No, definitely. I think the patent is extremely important, and it's
Mm-hmm.
also extremely expensive to get, like you mentioned.
Yeah.
And but it gives you huge amounts of profits. If, for example, it's like an invention, and
Yeah.
then you're the only person who can sell that invention. And a clear example to me is, the vaccination for COVID-19. Isn't that an example of a patent? Like Pfizer, they have a patent on their
They have
brand of
patent, yes,
vaccination.
of course. Yeah, most drug companies, most pharmaceutical products, they have patent protection. Yes.
Right, right. And then so for Pfizer, when they got this patent in the US, they have it for 20 years, right? And then
Mm-hmm. Mm-hmm.
so
For pharmaceutical companies, their patent rights, even though they have 20 years, it's they in most of the time they don't have get 20 years of protection. They probably have only 10 years. The reason is that it takes a long time to developing a product, right? When they have filed a patent application and then started to develop their product, and it takes probably 10 years to get just the product get approved by FDA, and after approved, they can only after approval, get the approval, they can marketing the product. So that's by that time they probably only have 10 years left for their patent life. So yeah, yeah, that's right. It's so and also a lot of products is not just protected by one patent. They have a patent portfolio to protect that one product. For example, for pharmaceutical companies, it's a vaccines. They can have protection for how to make the vaccine. So that's process patent. They can protect the vaccine itself, the active component in that vaccine. They can also protect the formulation of the vaccine, the concentration, what was there some other ingredient in that, this composition. So they have multiple patent protection. So that's make other people so hard to get in because the patent rights, even you have a patent, this a third party can your competitor can challenge your patent. When they challenge your patent, when they are successful, your patent just get invalidated. So it's not a protection anymore. So to get a strong protection, you just want to multiple patents. If one is getting invalidated, you still have other protections. So when you have a strong protection, people look at it and say, no, we're not going to challenge it. It's just too much.
Right, right. So, I mean, a clear example of a challenge, like a patent litigation, would be the Apple versus Samsung
Yeah,
lawsuit, where
yeah,
Samsung claimed Apple took its patents, and Apple claimed Samsung took its patents, and there was huge amounts of litigation in court
yeah,
in the
yes,
U.S.
yes,
Um, so,
yes, right.
I mean, tell us about what you do for patents, because I know you specialize in patents. So, tell us what you do in terms of um, helping your clients with their patents.
Sure. So the patents, as you can see, these just relate to technologies. So each patent attorney, they have their own specialties in the technology. So my specialty is chemistry, pharmaceutical, materials. So because I my bachelor degree is in chemistry, I have two master degrees in chemistry, organic chemistry, very narrow area.
Nice.
So a lot of my patent applications, they are just in chemistry areas. I just, for example, the new compounds. A lot of companies just trying to find small molecules, trying to find a cure for a certain disease. They're making a huge amount of compounds and then testing it, and just get a filing a patent application to protect those compounds. So the chemistry is my main area, and we also have biology side. This right now there's a cures of antibody using antibody using biology large molecules. So there's also some other way of cure your disease using the right now the biotech. It is a lot of advancements. There are a lot of new technologies. The people applying this to the treatments. So that's where we try and get in and protecting their inventions. So this is a very complicated area. So that's a lot. A lot of my colleagues have a PhD in their spatial fields. So that's they know the technology very well, and they have been trained. They went to law school to study patent law, intellectual property law, and they know the law side and also they know technology side. So that's why they can get you a strong patent protection. So the patent protection is just it's just all about just boiling down to claims. So how you define your invention, which one is your invention, which one is outside invention, other people is in public domain. This is a very technical. So that's my main part of our practice. That's we prepare patent application for to protect those inventions, and also another part of my work is we have to just some a lot of time just have to decide whether a product infringe other people's patent. So most companies first when they launch their products, they have to do a study. We call it freedom to operate analysis. Freedom to operate, which means whether your product infringe other people's patent. So launching a product costs a lot of money. So before you launch your product, we do the study, we search the patent, we're using keywords, we're using commercial databases to see what other people claims in their patent, what where whether this patents, where they file this patents, where the term of the patent, when will it expire. We're looking all these factors to determine whether your product is okay or not. If your product infringe a patent, we will advise that you should stop or you should change your product to make it outside of the scope of patent so that you don't get into trouble. Because patent litigation is very expensive. It's millions of dollars just for legal fees. And also you could be punished and have penalties. That's adding, you cannot afford it. So most business will just be more careful before they launch a product. They will just hire us to look into the patent. So what's the existing patents, and they will go in. They will just clear this patent first, and that's not enough in most cases. So they when they we clear for them, they and also another way just give them some protection, just filing a patent application. So you can see a lot of patent application get it filed, not just because they want the protection themselves, but also because they want to make sure they do not infringe other people's patents. Because when you file your patent application, it get published. When it get published, it's prior art. Prior art just will prevent other people to get another patent. So that's the idea. So you publish it, nobody else can get a patent. If you don't publish it, there's still a chance people get a patent. So that's why you file a patent application, and in the same time you do your search to make sure you don't infringe other people's patents. So
Right,
this
right.
is this is a little bit
Yes.
complicated. So
No, no, it totally makes sense to me because, like, for example, if I was like someone trying to come up with an invention, and trying to sell a product, I don't want to make that product, make like 1,000 prototypes of that product or a
mhm,
thousand copies of that product, and then find out later that someone else has a patent on it. So I
mhm,
would come to a firm such as yours. I'll come to you and ask you if my product is patentable,
mhm,
so that I can have the exclusive right to use that product to sell that product
mhm,
to the audience, and
mhm.
then after you filing the patent and having it approved, then I'll make 1,000 copies and then make millions of dollars based on that.
Yeah, yeah,
So
yeah.
no,
Mhm.
definitely. So how do you help international individuals or international companies in particular with patent protection or patent registration?
Yeah. So we do have a lot of clients. Is multiple international clients. They have multiple offices, manufacturing places, plants, R&D centers all over the places globally. So for us, we just the first step for us, we look into their invention, and we will let them know whether it's patentable, and if it's a strong invention, and we will suggest to them where they should file the patent application according to their markets, right? If they plan to sell their products in certain countries, we'll suggest you should go and get a patent protection in those countries. And also, we will look into what are their where their competitors are. So we will just if also file the patent application in the countries where their competitors operate, so that their competitor cannot make that product, right? So that's the idea. So it's yeah, we there's this a big process. It's a process of getting patent protection can last for 5 years. Even after 5 years, you get a patent. You are still we will maintain the patent for them by paying annuities. It's just a fee we need to pay to the patent office to keep it valid. So this annuity payment part, and that's the whole process. And sometimes we need to monitoring the patent and or the competitors whether they infringe your patent. So we have to be. So this is we can help in this whole process.
Great. So not only do you help register patents in the US, you also recommend international clients to other countries, offices in
Yes.
other countries, where
Yes.
they could potentially protect your patents there too.
Yes.
So, I mean, that's amazing. So,
Hmm.
because as you know, international trade, it's everything is global now.
Yeah.
Um, an iPhone doesn't just exist in the US, it exists in
Of course.
Canada, in Mexico, in Europe. It's just everywhere, and
Of course.
everybody's interconnected. So having you as that counsel to go to for protection anywhere, that's
Hmm.
I think
Hmm.
that's what my audience is looking for.
Yeah.
So
So just to clarify a little bit, so the patent councils. So each country they have their own rules to get a patent. So each country they also qualifies their patent attorneys, patent professionals, individual countries. So as far as I know, I think almost all countries requires a some kind of certificates to practice in that countries. So patent professionals are highly qualified professionals. So we have a very good network. So we have in our network we have Japanese patent attorneys, Korean patent attorneys, Vietnamese patent attorneys, Taiwanese patent attorneys, Chinese patent attorneys, and European patent attorneys, individual European countries, UK patent attorneys, Brazil, Mexican, Canada, you name it. Each country have their own patent attorneys. So we have this network, this big network. So when we file a patent attorney, file patent application in Canada, we're using a Canadian patent attorney to get this job done. So all this job is done by a local council. So yeah, just let you know. So we are not going to those countries individually. We are using our network to do that.
I see. And then when do clients come to you? Is it when they have an office in the US that they use your firm to file internationally, or how does it work? How do you get clients to make you their primary point of contact for patents?
Yeah, that's a good question. So, if the client contact us, we will be the one point for them. They don't have to know in other patent attorneys in other countries. We are the contact point. We're going to take care of everything for them. So we can just represent every single clients in the whole world, in the US. But yeah, we can file patent application for them in the US, and if they have meet certain standards, we can also file a international patent application for them in the US. So the international patent application is a treaty. So under the treaty, you file this application, and all the member countries will recognize that you file this international application. That's almost counted as the same you file in the individual countries. So most
Oh,
countries are in that treaty under that treaty. So if we file a PCT application in the US, so it's almost like we found this application in China, in Europe, in Russia, in Japan, so many countries, and you can
right.
wait for 18 months, or sometimes it's 30 months. It depends on how you get it file this application. So to decide which country you want to get into, so that's a deferral. You can defer your decision to get into which countries, because within this 30 months, you probably have developed your products. You're making improvements. You will know after within the 30 months how successful your product can be, and is very successful and has a very big market. You can file in many countries. If you think, oh, it's probably not very good, very a huge success, you probably can just file in a few countries, maybe it's 2 or 3 countries. You will save you a lot of costs. So that's the international patent application. So the international patent application just give you a right to get into the member countries. So you still have need to get into other countries. This patent application will be examined in individual countries. So that's how we can help your clients if they just considering filing an international application in the US and later going into other countries. For to file an international application in the US, some one of your at least one of the inventor or your the applicant should be a U.S. citizen, U.S. resident. They they have a U.S. place, address here, or their businesses have an office in the U.S. That's the requirements to file a international application in the U.S.
Okay. I
Yeah,
mean, that
yeah,
makes sense. That
yeah.
makes sense because you're filing within the U.S. to protect overseas, so you need to have some connection to the U.S.,
That's
such as
right.
a business.
Yes,
So, but yeah, I mean, one thing about immigration law is, which is I specialize in that, is that a lot of people they want a green card,
mm-hmm.
maybe not through the family process, but through the employment process.
Mm-hmm.
And one way to show that your employment or you're qualified to get a green card is that you have a patent that shows that you're exemplary in your field. So, I mean, if, for
Yes.
example, you were to help them with their patents, they'll get their green cards. So
Okay, good.
it's a win-win for everyone. They get $1 million and they get a green card. So
Yeah, yeah, yeah.
so but yeah, I mean, thanks, Martin, for appearing on the show. Do you have any last words or any advice for prospective clients, international businesses, immigrants, anything?
Yeah, they just welcome to contact us if they have any question regarding intellectual property, regarding trade secrets. Even they have technology, they don't think they can just realize that technology, commercialize the technology themselves. We still can help the clients to realize it, to get a patent protection, and to license it out to another party so that they can just collect royalties, just they collect money because they have a patent, right? So, so this
Right.
or they don't have a technology. They want to get a piece of technology. They want to use that technology. We can also help them to negotiate. Maybe we found some company hold a patent, but they do not using that much. We can just license in that technology so that you can put in your product, and when you get the license, it give you a advantage over your competitors. So if you have a good idea or just any idea you want to just protect it, it's a invention you want to protect it. We can help them to get this process, and if they get a patent, as you said, they in their green card process, it will help them, right? They are so
Right.
very yeah, and also they if they want to open the business here in the U.S. Anywhere, they probably need to just protect their the identity of their products or their service, their stores, the store name. Those should be also protected. Otherwise, if you using store name and somebody register your store name and you will lose that right to using your store name. That's can be protect and trademarks. So
Right.
if
Right.
they can just come to us to help them protect their trademarks. So that's
Right.
yeah. Anything in the intellectual property area, probably people don't think that much about it. But it's really important in the U.S. So
Right. Right.
if they think ahead, they can be very successful.
Great. Yeah. So again, everybody who's listening to this podcast who has an invention, who wants to expand their business, contact Martin. He's super smart. You know, he has 2 masters in chemistry. We both went to the University of Connecticut School of Law, and I encourage you to reach out to him and his team for all your IP needs. He can introduce you to international contacts to make your business from point A to point Z. So there we go. So thank you, everybody, for listening, and that concludes another episode of Lawyers for Immigrants. You can find our show on all stream platforms, Apple, Spotify, and more. And I encourage you to continue listening and sharing. Thank you very much. You put the grant in immigrant.
Great.
You've been listening to Lawyers for Immigrants with your host, Yifei He. You can find prior episodes on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and at www.yifeihelaw.com. Thank you for your positive reviews, comments, and sharing this show with others.